No, no, it's only this transaction.
180, no, 180.
There's only 72.
That is 18 crores settled at 60 lakhs.
So that is not an operational claim.
In fact, Lord, they got mixed up with the facts, Lord. I'll tell you, Lord, Lord. Now, I tell you, Lord, what happened was there were two.
He's got two separate
transactions. There happens. There is multiple transactions happen. Depending on the
same.
One
Civil appeal is dismissed. 16.
Arbitration or what? Petition is already.
Where is the interest portion you are challenging now, and where is the ground?
Just one second. Give me one. The 34 petition is on record, print. 34 petition is not on record, but just
this entire selective filing here.
Listen, I understand. Last
we have to draw up perhaps
I understand that, but
adverse inference from that.
But please see, 21% is contrary to the.
Unless you raised it, where is the question?
Plus, that petition is not here, so I can't say that. So, Lordship, I just pass it over. If I get it, I'll file it. No difficulty.
21% post award.
Post award.
34 and 37, both are
both,
not here?
Both I'll file. Both I'll file.
Sorry.
Petition filed under section 34 of the Arbitration and Conciliation Act.
37 is
grounds raised.
No, just one second. The 34 is there. I'm so sorry.
34 is there?
Yes, just give me 1 second. Just 1 second. Page number 113. Just give me 1 second.
113 is perhaps your 37.
37 is there. Sorry.
34 is not.
But I'll file 34.
Filed under section 34. That will be placed on the record by the next date of hearing. This term. 28 July.
28 July. Great. Obliged to.
Item number 17.
Yes, sir. Look, sir, civil appeal under the stay act.
My lord, please just let me give your lordship a basic and show your lordship how it went wrong. This goes totally rewrites the Supreme Court judgment.
I don't really. It up after the
Break.
in July.
Very good.
Just skim through the orders. Really read it. And
16.
this kind of volume, it's impossible to make up a matter.
That's right. The last line. July minutes.
Rewritten the earlier judgment on which we succeeded.
It's hardly a remand order also.
But anyway, your lordships will.
This term.
First week, if possible, my lord, because it's a miscellaneous. Very miscellaneous.
14 July.
I am very well.
Great.
Item number 18.
In the previous order.
And that will be the of the judgment. My brother is a Banwari Devi or something.
I'm only on two issues, my lord. First,
Secondly, on facts also, the finding is they
The
filed in
application was filed in
2003
2007.
and it was repeated in
2007.
2007 and was repeated in 17.
may just make one submission, my lord. The award, my lord, is 8th of December 2006.
6. Application is 9th March 2007.
Which will be on 90 days. It is not within 90
Manage
days.
the
Not on that.
These are all matters you yourself have to seek out. You
Not on
have
that.
all the records of people. You have to go and give once somebody is increased.
But I'm not on that. My lord, at page 71, the Honorable High Court records the contention that there is collusion of anti-rating because till 2012 there is no notice in that application.
That they were called for the file, gave it to Mr. Adarsh Bhushan, I think, if I remember memory of counsel right. And he saw it and then he was satisfied that there is no anti-dating.
My lord, if you look,
Same answer.
71, my lord, the notice issued is in 2012.
Nothing.
Not in these kind of matters, poor things.
We find no good ground and reason to
Grateful.
everything to that. The special leave petitions are accordingly dismissed.
If it may please, my lords.
Yes.
My lords, in para 39, 38 and 39 of the interim judgment, the Honorable High Court has said that there is no admission of liability.
Is your daughter-in-law?
My lords will see, my lords, there are a lot of disputes, but my lords will just see.
So you're bringing your private disputes into this?
No, my lords.
Somebody sued?
Ms. Bhandari, it's not only a tribal issue, it's a trying issue.
Is your daughter-in-law? Where is the question of
My lords will
package
just
of
see.
court?
My lords will just see two.
Unconditional leave is granted, so you take.
My lords will just see 206.
You now want to pin her to that 25% of the.
My lords, yes, my lords, because what she is trying to
And,
do
that,
now,
and,
she's
that
filing.
make, and your mail of 18.3 has a giveaway in para 2. Normally, mails are not written like that, if written in own volition.
She
Page
has
44.
written the email.
I know, she's claimed to have written the email, page 44.
No, my lord, she'll just see page 100.
She said, I signed wherever my husband asked me to sign.
You read para 2 of that.
I see
Will
that,
anybody
my lord.
write in that? You read the para 2?
Since, my lord, since 16.4, we are staying separately and never met for any business transaction, nor any paper is signed by me.
He's also writing, I have never met you, I have never had a transaction.
My lord,
He's covering up some other ground somewhere else.
My lord,
Sorry.
my lord will just see 2 pages.
Not a case for this.
Then my lord will, if my lord is pleased, if my lord is inclined to dismiss, my lord, what she has done is she has now filed a fresh written statement in the Bombay High Court where they have to decide whether to take it on record. What she has done in that written statement is she has effaced this admission. My lords, I have a copy of the written statement. She
We
has,
don't want to go into that.
my lords, but then she's changing stand, my lords, and they'll say.
Whatever issue you want to take up there.
My lords will just say
Find
that
no ground and reason to interfere with the impugned judgment, especially petitions according to dismissal.
Number 20.
But I'm being led by Mr. Ranjeet Kumar. He's stuck in another court. I request for a pass over.
In this
That's,
case,
I'm
the
seeking a
statement
pass
of-
over. Mr. Ranjeet Kumar is on his legs in
This is
another.
item 20.
Yes,
My lord,
I kindly pass it over for.
Very well. Pass over. This perhaps I will not hear this. It's my judgment. Oh, okay. So even if he's asking only for extension of time, it may not look proper for me to do it. So list before a bench in which one of us, KUMARand, is not a member. He's just asking for extension.
My brother will know this.
Please, my lords.
Yes.
Thus, in item number 22, there are 4 or 5 submissions. First is, my lords, the basic mandate or the prerequisite or invoking section 43. That is not fulfilled, which is, my lords, I show the pages also, which is that I should be a creditor in the first place. And I should have been made a payment in preference to other creditors in the queue under waterfall mechanism. So not a whisper as to what debt was owed to me. On the contrary, my lords, at a page in the forensic report, it says payments have been made for no specific reason. So that is A, my lords, not fulfilling the mandate of 43, and B, my complete non-application of mine. Second, my lords.
Your only ground was that these transactions were in the normal course of business, which you were not able to prove.
No, my lord. So, which is what the forensic report and the NCLT say, but that is completely wrong. My lords, may kindly bear with me for 2 minutes, my lords, and the other 2 points, my lords, which are very important. The forensic report, my lords, page after page, para after para, itself says inconclusive, not determined, and so much so that it says seek professional help to determine whether this forensic report is right.
How is fraudulent preference found? Show the finding.
Yes. My lords may have page 53. That is the appendix. Appendix, my lords, 1. Page,
Not the section.
my lord.
On facts.
In that report,
In the
the
report.
forensic audit
Yes.
report, how does it pin you down?
The report starts from page number 76, my lords.
Hmm.
The relevant parts are, my lords.
Yes.
My lords may have page 86. Page 86, point number 2, my lords.
Hmm.
Says we have not been able to verify the following considering the necessary details are not available. Then page 87, my lords. Disclaimers, that's very important, my lords. The report is based on.
We are asking you for the finding against you,
My lords,
not for.
my lords have that.
Yes.
We noted that the company had given advances to directors as explained to us. This was for incurring business expenditure. There are 2 accounts maintained in the books for the same. namely Nagaraj advance account and Arun Kumar advance account. The debits in the account represent parties and credits. The explanation which has been the same, my original position in the statement of objections as well, which is the forensic reports only considers the advance accounts and doesn't consider the loan account. If it considers the loan account as well, then it will come to the finding that more than what the company owed, what I owe to the company owes me more. So for that, my lords may please have.
Where did you raise the content
Yes.
that there are these two loan accounts which need to
Yes,
be looked into?
page 149. 149 is my objection, statement of objection to the section 43 application filed by the liquidator. This is where I explain in detail, my lords. Actually, from my lords, page 147, I correct myself. Para 9, page 147. The forensic audit report in the table at page 8 under the column makes a noting. This is the noting my lords have just seen. At the time of the forensic audit report itself, it was sufficiently clarified to forensic auditor that there are not 2 accounts but 4 accounts. The forensic auditor conveniently ignored the remaining 2 accounts, Nagaraj loan account and Arun Kumar loan account. 2 accounts have been ignored, which are also maintained in the books of the company and the extract of the ledger for the period from so and so of
So
Nagaraj.
you receive money from the company and then you give a loan to the company again.
My lords, and the loan given to the company is in the sum.
And what are you doing with the amount which you receive?
For the
No
general
expenditure is shown there.
No, my lords, that is a fallacious.
Is the same amount being given as a loan and thereafter you get interest
That
from
is
the
being
company?
used for the general purposes of the company, my lords. And my lords may kindly see one paragraph, my lords.
Have you shown us the additional report of the forensic auditor?
There are 2 reports.
That is with regard to my lords. That is with regard to 11 lakh extra, which is with regard to appellant number 3.
Yes.
And therein also, my lords, after a year, just from the conduct of the auditor, after a year they find out, they say, we have missed out on this 11 lakhs. So what due diligence, what exercise they did in the first place, my lords, which is my whole case. And my lords may kindly see.
You come to page 198, para 11.
My lords, I have that. It is seen, my lords.
That's the NCLT order.
My lords. In respect of original forensic audit report as well as the additional forensic observations have been made by forensic auditors and the figures, there too were supported by the bank statements.
Bank statements.
Bank statements. And the respondent failed to dispute the bank statements,
Yes.
basis which the audit report has been prepared.
So your stand now that in the reconciliation, the corporate debtor owes me more.
My
What
lords.
you are saying?
Yes,
So it can't be preferential because otherwise,
my lords.
why would they further owe me? Where is that brought out?
My lords, that is there in my statement of objection, which my lords have just seen, that they failed to consider. I'll just show it again. And while we are at para 11, my lords, my case was never that the bank statements are dubious. My case was always this: bank statements for advance accounts have been considered, wherein shows how much money company has paid to me.
So did
But
you lodge a claim? Since it's corporate debtor owed you money.
My lords,
So what will happen? You would have lodged a claim.
my lords,
Did you lodge a
I
claim?
would have.
Did you lodge a claim?
I will have to seek instructions on that.
Yes.
I'm sure, my lords, we would have. I will have to seek instructions. Before that, my lords, allow me to. Maybe it is not there because maybe perhaps it wasn't in the.
So the easiest way to show is no ordinary preference. Where is the question of 43 lakhs being given to me? They owe me much more. So here is my 14.
I understand, my lords.
14.
My lords may give me time.
Per day, contemporary
I understand. My lords may give me time.
That is the most
instructions on that.
crucial aspect. Where is the question of you saying that you don't know
So
about it?
defense is that they owe you money.
My lords. But before that, my lords, kindly just have section 43. The basic ingredient of the section is not made up. Just please have section 43 for a minute, my lords.
Is it within the look back?
No, so my lords, I'm on this point. 43(2). It says a corporate debtor shall be deemed to have given a preference. It's page number 53 foot of the page, my lords. Preference, and this is important, my lords. There is a transfer of property for benefit of a creditor, surety, guarantor, or on account of antecedent financial debt, operational debt owed by the corporate debtor. So what is important is, my lords, that payment has been made in discharge of a debt that the company owes to me. Now, please keep this in mind and please have this finding of the forensic auditor, my lords. My lords, 92, page 92. Page 92, the finding of the auditor. My lords have that? It is clear.
Yes.
It is clear from the above that there is a significant increase in balance, no corresponding increase in expenditure claim. Now, this is very important, man. Amounts have been paid without any specific reason. So, neither there is any inquiry undertaken, not a whisper as to what debt was owed, as to whether I am creditor or not. On the contrary, it says payments have been made for no specific reason, for discharge of no debt. So, the basic ingredient of section 43(2) is missing, my lords. And with this, my lords, may also see the forensic report. My lords, may have page number 87, my lords, of the audit report.
There's no mention of these people filing.
Page 87.
87. My lords, have page 87.
Yes.
The second paragraph. This report is based, my lords, have that?
Yes.
Exclusively on the facts and circumstances described in the engagement of team for conducting forensic audit, as given based on representation express or implied and based on our interpretation, which may differ to other person.
No, you stick to your objection that it's ordinary course of business. What will be placed to show that it is ordinary course of business, it is not a
My
preferential
lords.
payment.
And what did you do with the money? There's no expenditure.
I have further money to be received. Here is the claim I have contemporaneously lodged.
There's no mention of your filing a claim in the RPs.
So, my lords, may, if this is what is bothering, my lords, may give me some time, a week's time, I'll seek
What's the point
instructions.
of your preparing on the legal position without going the factual background?
No, I file an affidavit to this effect.
And you still don't have any proof of this transaction being in the normal course of business.
Ordinary course. What ordinary course of business?
My
Is
lords,
it a concern?
Why would you receive such a huge amount when compared to the earlier year? For what reason is this huge amount given to you and you show no expenditure for it? So it's obviously to
even then,
divert the funds of the company.
no, my lords, even then. So, what is important, my lords, is if it is for diverting the funds of the company,
Very counsel.
company owes me more. Company owes me more.
Counsel for the petition, for the appellant at length, we find no good ground and reasons to interfere with the issue judgment. The appeal is accordingly dismissed.
Please, your lordship. Section 23 of the Consumer Protection Act. Lord, the surveyor has assessed, firstly, the fire was doubtful, and then the surveyor has assessed 46 lakhs and odd, my lord, in his report on stocks as well as the building. The NCDRC of their own has given 2 crores 40 lakh rupees, my lord.
Total amount 46 lakhs.
46 lakhs 97
We'll
9.
make it 50 lakhs.
Yes. Approximately.
Issue notice. Returnable on 23rd September. So to the appellant depositing a sum of rupees 50 lakh with the registry of this court within
6 weeks.
within 6 weeks. There shall be stay of operation of the improvement judgment. The amount so deposited shall be fixed deposit paid and the amount so deposited shall be invested in a fixed deposit in any nationalized bank for a period of 6 months with an auto renewal clause.
My lord, delay we continue.
Delay con-
Highly pledge.
That this, my lord, it needs to be settled because Order 8, Rule 1, as it originally stood,
Claim is in the nature of a separate suit.
true, that is a theoretical proposition, my lord.
That is a.
Let me just, my lord, explain why, my lord, this is an important question. Order 8, Rule 1, originally as it stood, did not have a penal clause. It didn't have a clause that if you did not, then it will stand forfeited. That penal clause, my lord, is inserted in Order 8, Rule 1 only by way of the schedule of the Commercial Courts Act. There was a separate.
6A3 has not been considered.
Exactly, my lord. So if it is a penal provision like that, forfeiture is involved, then, my lord, it is a different question of
You
construct.
can't just
You are
apply
appearing on-
You cannot just apply a theoretical principle.
principle.
As a legal proposition also, this needs to be.
What is answered?
At least Madras High Court has taken a
6A3
view.
has-
Madras High Court has taken a view, but your lordships have not considered it. Your lordships have considered in the context of a counterclaim, counter statement, plain written statement, plain written statement.
There's a
Why is it
reference
called
to another
additional
judgment also.
statement in this?
Right, because there's one written statement.
There is already one written statement.
Actually, there is a concept of additional written statement in CPC. You know,
That's a separate one, my lord.
that is where the defendant files
Yes,
after the written statement.
that's it. That's
This should be called a written statement to counter
To the
claim.
counter.
But you repeatedly call it the additional written statement.
But that is what it was called originally also in 6A3. Well, that other additional written statement is in 9, which says that you will not file anything further without the
Period for all the respondents.
Lord, I appear for one, Lord, but
Only
there is
one.
a correct answer.
Which respondents are you appearing for?
R6, respondent.
R6. Issue notice, returnable on.
The two courts have considered, my lord, respectfully, my lord, 6G has considered.
Since the consequences are drastic,
Returnable on.
if it is to be held to be mandatory, there must be an
15th
express
September.
sanction. That is the law on construction of settlements.
Learn counsel appears on KV for respond number 6. And waits for the notice. Notice shall be made on all, service of notice shall be made on the other respondents by all modes including custody.
Will it stay off the suit in the meantime? They should not proceed with the suit.
Stay of. Suit number is
440.
440 of 2024 is the current number.
stay of suit number
It was originally
44.
something 440 of 2024.
440 of 2024 on the file of,
This is the High Court, the original site of the.
on the file of.
We'll file a counter within 3 weeks, my lord. This issue has to be settled, your lord. Your lordship may keep it for final disposal after service.
Sorry,
Yes,
3 weeks to file
we've
counter.
given you a date, September 15.
Readings can be completed. They can.
Reading shall be completed in the meanwhile.
yes.
Is it a non-miscellaneous day? Because then we can argue it from there.
15th September is perhaps Monday, Mr. Rai. You want a referring date, is it? Very well then. 16th September.
Great.
Yes, keep your.
Let me know.
Yeah.
So this is against the demolition that was carried out.
Concurrent findings.
No, not concurrent. Not concurrent. City Civil Court and.
Trial court dismissed, appeal dismissed.
No. This is an interim stage. At the interim stage.
Oh, where are we? Which matter?
Item 20.
Oh, sorry, I'm looking at the wrong.
I'm so sorry.
This is Gauri Court's order.
Where?
Yes, that's.
Correct order.
Now, Lord, may I just try
This
since your lordship try.
cancer patients were being treated there, and you break down.
No, no, Lord. So now, please permit me to make 2 or 3 points and then I'll develop.
Answer one point.
Yes, sure.
Did you offer the person 538 square feet?
No,
accommodation
now, just one.
before
Now,
you demolish this?
no, now, correct. Now, very important question. In the demolition order itself, now there are 2 ways in which these people are compensated, either by way of giving them temporary accommodation or money. In this case, 35,000 per month was offered. It's mentioned in the demolition order itself.
Did you give him the 444 notice? Because
This was not a final notice.
earlier proceeding was in 23 October.
Correct.
After that,
Yes.
he serves you a notice saying he's moving the civil court in the afternoon.
Yes, correct.
And you go and demolish it.
No, my lord, my notice is of October 23. My notice
When
is
the
of.
High Court asks your officials to appear, they don't.
My lord, now goes, my lord, on that aspect, I can't really say now. They
The
did not
same
approve.
high-handedness, the approach is the
My
same.
lord, as long as I
Dealing with the citizen or even with the court.
I understand what your lordship is saying, fully I understand, but please just permit me to make 2 points and then whatever your lordship says, of course, we'll do. Now, my lord, the first thing is, his suit was mainly, the tenor of the suit is what? That I should get 1319 square feet, not 538 square feet. That's the tenor of the suit. In the demolition order itself, he's recorded, his own submission is recorded, that as long as you give me 1319, I will vacate immediately and you can pay money. It's recorded in the demolition order, his own, here, it was a hearing, we gave him a hearing, my lord.
Then you never gave him a commitment. Even now, the order is only this much, that temporary accommodation is 1319. Entitlement is what is otherwise.
Correct. Now, but temporary accommodation can't be given by the corporation is the point I'm trying to make. No, it's never given by the corporation.
Temporary.
You need to, when you demolish this property like this.
Below the developer, in this, below the developer has to give it, the developer has already given him 35,000 a month
If I know.
on the, this. Now, below also
Great,
now,
Mr.
please
Patna.
take costs, etc. Below in a case like this.
Because definitely, this is a, in fact, they should have imposed more.
No, that's your lordship's view, but I was just saying there's 2 points taken. His only case was 1319 in
Find
annexure.
no good
And he's not even challenged the annexure A2.
Because
He actually supplying food to the cancer.
My lord, this was an illegal construction. Now that the matter is over, let me tell you lordship what I actually did. It is an illegal construction. He had 538, which over time he expanded to 1319. And that is why the annexure 2 of
Demolished only less than 538 or left 538?
No, we had to demolish the whole thing. Well, the demolition order said the whole thing. That's why I wanted to show the lordship that that's all he wanted. I'm all right. All right.
We're happy.
But would your lordship just give me one little indulgence? Since there's some time now, time has been given to give him temporary accommodation. Now to find temporary accommodation in these areas is very difficult. Please give me a couple of months at least for that.
No, not at this stage. And he's not even before. Oh, someone is appearing.
No.
Sometime.
Blind man wants a
Time
9
is extended.
And
They can give
the
me
order by
1300. Let him give me.
no, he'll get what he had. 1300 or whatever, he'll get.
whatever. Time is extended by 4 weeks
Correct.
from today.
And just one other point, Lord, that this is an interim order, so whatever is held may not prejudice the suit if your lordship may consider.
We're not-
All right, oblige. Very good.
This is the concurrent finding.
Yes, may Your Honor. Whether the plaintiff ratified this honorable court with regard to 3
You
requirements.
have to show it was.
That's right. May Your
You
Honor.
can't just say I've been in possession, therefore I need to.
May Your Honor. Defendant admitted that, so they have given possession for cultivation, but my plan is that agreement to sale. One is possession accepted. Second one.
Findings
is
of fact,
since
sorry.
1987. Your Honor,
Findings of
Only
fact
2 points, only 2 points. 1 point I can.
lost for all the
That's
courts.
right, Your Honor. That's why.
The only indulgence we will show you is condone the delay.
Your
206.
Lordship, other 2 points only 10 that evidence, Your Lordship, only 2 points. One about the possession they admitted in page number 46.
You may have been in possession, but it needs to be
And
shown to be adverse.
Yes, Your Lordship.
Where?
Your Lordship, the adverse is
One
all
owner,
the witnesses.
one owner executes the agreement, the other man is not
That's
in the
right, that's
picture.
why I admit. I haven't filed any application of suit for a specific performance.
It has the tenor of a permissive possession also. And secondly,
And
we have not pleaded the dates for next week.
That's right, I can see.
Then I condone. We find no good ground and reason to interfere with interim judgment.
Yes.
Petition is dismissed.
Please, my lords. Issue pertains to construction of the common area between property A and.
Again, finding of fact, whether that
My lords,
courtyard,
finding of
what
fact.
is the nature of that courtyard, whether you need to give half, they need to give half, or whether the entire thing has to be given by them.
But still the construction cannot be permitted.
Purely questions of fact.
Page 5, para 9 of the
And
High
you don't
Court,
seem to have adequate.
where High Court categorically observes that 100 square meters is actually common area. How can construction now be permitted on those 100 common area? My rights are prejudiced. How will I?
We can't decide this
High
question.
Court order at page 54 is fairly more clear.
My lords, the High Court order at para 9. For a minute.
Para 9.
Para 9, page 4. 4 lines from the top, after leave. What was kept in common was the courtyard in between. This is a factual finding given. What was kept in common was the courtyard in between CTS number 3A and 3B. The said recitals cannot be termed. So as a matter of fact, the courtyard is common. Now in 3A, most part of it, the map is annexed along with the IA. If my lords looks at the map, 90% of the common area falls in 3A. The construction is being carried out in 3A. Later on, what the court says is that since my brother sold it to subsequent, purchaser, in that sale deed,
You
there
are
is no
trying to
mention.
shift the common area to the
other side.
plot. Whereas it is half here, half there is the.
No, my lords, the map. My lords, the map is annexed with the eye.
You are trying to
There's
shift
no
it
clarity
to
there.
everything.
My lords, it's an official map. My lords, please take a look
The
at
High
the map.
Court, in fact, records that.
And
the
that
said
is
recital cannot be torn out of context to mean
My lords,
that
because-
it has to come only from CTS number.
because the subsequent sale deed between the purchaser and my brother does not talk about it. My lords, would please take a look at the map. Please.
Sorry.
Just one document. My lord, the map.
Purely a question of fact.
My lords,
You
I'm
can
just
decide this.
highlighting that.
Sorry. You find no good ground in this.
My lords, then may I request this? May I request this? Let it be observed that the construction, whatever is happening, is subject to the outcome of the suit and no equities shall be claimed. At least that part can be, because tomorrow I do not want the
The
trial.
silence will anyhow apply, whereas question.
My lords, it's about claiming of the equity. At least
The
those
suit
options.
is pending, is it not?
Correct. So
Whatever happens is already hit by that doctrine. So
my lords,
nothing
just
needs
the
to be
recording would help.
nothing needs to be said.
Please, my lords. Yeah, my lords, at least the final, the observations and exhibit cannot be,
Dismissal of the special leave petition
or even the
shall not be taken, and the observations made in the impugned order shall not be taken to be expressions of opinion on the merits of the matter, and it shall be open to the trial court to deal with the matter independently and on its own merits in accordance with law.
Great, Your Honor.
Please, Lords. This is an item 28, the limited issue for Lordship's consideration is because that the vital piece of evidence has been overlooked. Because there is, the respondent number 1 was my retailer. Whereas the agreement or the proposal had 2 stipulations which are considered by your Lordship. One was that I was to pay him a minimum guarantee of 1.72 lakhs. And the second was an obligation on him to maintain a minimum stock of 25 lakhs. Now, the trial court notes that these two are not related. There is nothing stipulated in the agreement that he would not be entitled to minimum guarantee in case he does not maintain the stocks. So, which is contrary to the evidence given by the managing partner of respondent number 1. If your Lordship may just see, Lords, page 159, para 6 and 7. He himself admits his understanding of the contract. Plus, if I can draw your Lordship's attention straight to page 160.
Yes.
Plus 4th line from the top, I have produced, I'm reading from there. I have produced the document to show that how many goods have been sold in the discount sale. It is not true to suggest that I have not produced any document. I know the difference between dead stock and whole stock. It is true to suggest that to claim monthly guarantee and other benefits from the company, we should have stock of minimum balance worth of 35 lakhs.
Benefits.
To claim the
He is asking
guarantee.
effective fees reimbursement as finding at 205 of the trial court.
Lordship.
This 44 lakhs. He produced bills, vouchers, which the customers have come and returned, all that.
Because there are 2 aspects of it. The one
15
was the
lakhs
minimum
was one and
guarantee.
17 lakhs worth goods.
One was the minimum guarantee for which he's been was allowed 24 lakhs. That his own understanding is also that it is related to him maintaining 25 lakh rupees stock at all times. And because there is only one pager proposal which ultimately became an agreement, which stipulates obligation of both parties. I say I'll give you minimum guarantee. He has to maintain a stock. This aspect below is being completely overlooked.
No, the statement doesn't really help you because he's only saying that the monthly guarantee and other benefits we need to have the stock. But
Because if I can then draw your lordship's attention to the proposal which ultimately is
Shankar, para 22 at page 205.
May I read minutes? Plaintiff has also produced copies of emails sent to defendants by intimating the supply of defective materials and non-payment of minimum guarantee and margin money on sales, and also requested to send an authorized person to rectify defective materials, which are exhibits P80 to P20. On perusal of the same, it appears that the plaintiff has sent the email to defendant number 2 with images of defective material, damaged shoes and footwears. The plaintiff has also produced copies of claim forms given by the customers. Now, this is the other aspect. This is on defective goods. On that also, there is no evidence shown, no local commissioner appointed ever.
2 courts have held against you.
Because I am only on the limited aspect of minimum guarantee that he has been awarded, which amounts to 24 lakhs. Which there, so one pager agreement, Lords, which stipulates obligations for me and him. If I can only draw your lordship's attention to that for a minute, which is Lord's Annexure P1, page 48. Because in these kind of contracts, these are not detailed contracts, because the proposal takes over. So this is what we have. The lordship will see para 3. You will be supplied, plus that may not be relevant. Para 5, at any given point of time, you have to keep a minimum stock of 25 lakhs in the store so as to ensure proper and wide display of our merchandise. Now that's an obligation for him. And 9 is what he's claiming. We would be assuring a minimum guarantee for the Bellary store. This would be 1.72 lakh. If your earnings from sales at the store is less than this amount, the remaining amount would be reimbursed by you to you by respondent number 2. If there is no obligation of 4 on him, because of clause 5 on him, then a retailer like him can just sit back and relax.
So he needs to keep 25 lakhs irrespective of whether your minimum guarantee is being sold or not.
Because minimum guarantee is an assurance I am giving to him that
if it's not getting sold, so what is the he holding on to this 25 lakh worth of stock?
Yes, the security of 25 lakhs with you deposited.
No.
That's the finding.
What is that 50 lakhs that he's asked for? Recovery of 50
There's a finding that 25 lakhs is paid to you.
Because initially he paid 25 lakhs for the goods purchased.
Deposit, initial deposit.
Yes.
Initial.
That's it.
Nothing more.
You find no good ground and reason to interfere with the interim judgment, especially petitions according to this.
Item number 29.
29.
Yes, Your Lordship, in this, the petitioner has purchased the land on 4/9/2019. And after filing the application for demarcation, he gets.
This land was acquired in 1975-76.
Yes, Your Lordship, but
Then-
after he filed the application for
Then how
demarcation.
do you buy this acquired land and then say that a road is passing through? Obviously, it will pass through. It's already acquired.
Yes, Your
And
Lordship.
now you want compensation. They say that they've already paid compensation.
Your seller has taken the money,
Your Lordship, they have.
sold the acquired land to you, part of it.
Yes, Your Lordship, but they have not filed any relevant.
Where will they have? Really, because they don't have any proper record, doesn't mean that they've not paid. Why would he have kept quiet? And you don't buy it from him. The LRs have sold it to you. So they've taken you for a ride. Whatever rights you have against them. The government doesn't have to compensate you. Sorry. We find no good ground and reason to interfere with the interim judgment, especially petitions accordingly dismissed.
Without considering my interim prayer for
Your interim prayer was already considered and an interim order is granted to you.
which was
Learned judge has moved on and become the Chief Justice of India
that's
also.
correct. So, Malad, what
If
I-
that order is not acted upon,
yes.
is your remedy asking for another interim order after how many years? 2013.
Because I'll tell you what has happened.
You don't even file a fresh IA.
Well, that IA was not filed afresh,
Then
but I
you
was
already have an interim order.
That's
Then
true.
there is a question of
And
granting
that order
the
was
interim
violated
order.
by the authority, my lords.
Then you file a contempt proceeding.
Well, that order was, nothing was given to me in that.
Where is the question? This is just an admit order in a 2013.
Well, I had an interim prayer in that. I've still been out despite the order. Well, that's a point in my
You
favor.
have an interim order, you keep quiet about it, and that's.
Well, that's a
your
point in
choice.
my favor that the interim order has not been implemented. Surely that can't be used against me, Malaz,
That
because
is the question. You get an interim order, you do nothing about it. It's a 2013 writ petition, which is admitted now by way of the
it will
interim
come
order.
after 12
And
years.
you say you have not given me.
May I say
interim
one,
relief.
may I make one request? Because in light of what's falling from the board, may I make one? So your lordships just make, well, 12 years, after 12 years, the lordship that leave has been granted. It will take another 12 years for it to come. Your
No,
lordships
why
may
will it
request
take
the High
another
Court.
12?
Because it does take Bombay High Court, after leave granted, it has been consider requesting the High Court to decide it expeditiously, my man.
Move an application. Now the date is also
So,
given.
record my liberty. Give me just say record my statement that I'm making that, and with that liberty, I'm withdrawing the petition. Kindly just allow me that much. I'm making that request. Kindly record that, and with that liberty, I'm withdrawing the petition.
We find no good ground and reason to interfere with the interim judgment. However, we leave it open to the petitioners to seek early disposal of their case by filing an appropriate application before the High Court. In the event any such application is filed, the same may be considered expeditiously,
I'm grateful.
especially petition. Subject to the above observation, especially petition.
I'm grateful.
Lord, I apply for the petition. But my grievance here, Lord, is that the trial court holds me, Lord, the execution petition as not maintained. Lord, my submission is, Lord, there is a decree, which is a compromise decree, which will not efface.
As per which you never made the payment.
Lord, I have not made the payment. Lord, but I'm saying, Lord, the decree will not efface itself.
That's why the High Court said you're entitled to 50%.
No, Lord, but that
refund as.
Lord, kindly see now. Lord, I am now willing to pay the money, Lord. There was litigation between the parties. There was litigation between the parties, Lord. And please see, Lord, clause. Please see the clause, Lord, at page 40, clause 7, which is referred to.
Page 40.
40.
Of the supplementary.
Yes, Lord. No, this is the compromise.
The compromise.
This is the compromise decree. So the plaintiff and defendant agrees and admits that in the event of non-compliance of the terms of the compromise application and the supplementary agreement of the sale development agreement and cancellation of this sale deed effort, so that the defendant shall refund half of the total amount received. Now, my lord, the cancellation never happened. Your lordship will see. Lord, there is, my lord, non-compliance. I'm Lord, I can't say anything. But cancellation of this never happened.
Now, something is pending still.
No, my lord, there is another appeal, Lord, that which is also decreed. The other purchase.
How much you have paid, Mr. Male?
Lord, I have paid, my lord,
only 5 lakhs.
5
lakhs.
You paid 50%.
No, Lord, after that I paid 20 lakhs, Lord.
In that 1 crore 30 thing.
Yes, Lord.
So you paid totally how much?
25.
So you now get 12.
12
1 and a half.
Lord, the suit is decreed.
The second fellow.
Second purchase of lot and it is decreed, Lord, at a higher price, at 4 crores. Lord, at least the equity of Lord, money, Lord.
You don't abide by the compromise decree having invited it.
Therefore, I'm making a technical submission, Lord, that a decree, Lord, this is, I have not gone for specific performance.
It's on the issue limited, not on the question as of the quantum of refund payable to the petitioner.
He has sold it to the other fellow.
No, and it is decreed for 4 crores.
He may be in a more magnanimous mood, so let us see.
We had another case when we ordered refund of earnest money. The council was anxious to immediately do it, and he has mentioned twice to get the money released.
Very good. And the
List on issue notice return below September 15.
Wanted a clarification. This is already
Item number 32.
We wanted a clarification of your lordship.
So I'm raising a preliminary objection about maintenance.
104 plus your lordship's order.
The entire issue turns on that. That suit only. There is a question of you saying that suit has to be removed.
Well, and the API has finds out on the ground that the authorities are confused. There can be a ground.
Look, that's not the.
And after more than
That's same thing itself is subjected to challenge.
No, I don't understand why this act like. My clarification is not that this should be removed. Your lordships noted while passing this order that there is a 2001 mutation in my favor. After 19 years, a revision is passed against that order. Your lordships extracted that mutation order in my favor at page 105 in your lordships. What was supposed to be done was to maintain this as the revenue entry. Now, what has now happened?
It's order miscellaneous.
If I know.
Sorry.
I'll withdraw this application. I'll withdraw this application.
Non-council seeks permission to withdraw this miscellaneous application. Miscellaneous application accordingly dismissed as withdrawn.
Great.
Item number 33.
Yeah, please, Your Lordship.
The question of pre-deposits is actually taken up at the stage of section 11, specifically by the respondents. They choose to abandon that particular clause in the agreement. May kindly have clause 25 at page D. This is a pre-reference stage. May I read that clause?
Yeah.
It is also a term of this arbitration agreement that where the party invoking the arbitration is the contractor, no reference for arbitration shall be maintainable unless a contractor furnishes to the full satisfaction of the executive engineer in charge of the work a security deposit of a sum determined according to the details given below, and a sum so deposited shall, on the termination of the arbitration proceedings, be adjusted against the cost, if any, awarded by the arbitrator against the claimant party, and the balance remaining after such adjustment, in the absence of any such cost being awarded, the whole of the sum will be refunded to him within 1 month from the date of the award.
Where do you get it?
Well, this objection is taken by them at the stage of section 11, which is at page 32.
32.
Yes, para 3. The objection taken by the respondents as such that the security amount has to be made as per clause 25A7 of the agreement. Since the objection as such is formal in nature,
it's not given up.
But however,
It's left open for the
but it can't. This is a pre-reference. Please see the clause. Can you see the clause? The clause is a pre-reference clause. It is not a post-reference clause.
If the High Court left it open, then
they did not. It did not leave it open.
That is how this paragraph reads.
Well, it's just respectfully. In case under 16, how does it fall under section 16?
16.
Let's hear. The arbitrator has been appointed.
Council.
Also
dealt with this section 30.
It doesn't. In fact,
the arbitrator specifically deals with it. He refers to a judgment also.
In fact, Lombardi also doesn't deal with it. 31A is not dealt by Lombardi at all.
Sorry. We find no good ground and reason to interfere with the improved order, especially petitions according to dismissed.
Item number 34.
Great zone. Appellant. There's a certain regulation under the CRP regulation, which is 39(1)BB. As to when
arguments heard, judgment reserved.
Yes, I'm unfortunately, I am the promoter as well as the resolution.
So you already know what the judgment is going to say. So in anticipation of a negative judgment, you've come, is it?
Most respectfully,
how can you maintain
in the first hearing,
an appeal against a judgment reserved order?
Just permit me to say this. Here is a situation, where I'm an MSME. I place my plan.
You're not on the merits. How do you maintain an appeal against a judgment reserved order?
It was a statutory appeal, which I had filed before the
tribunal cannot
reserve hearing. In the first hearing,
is there a bar against reserving judgment on the first hearing?
My
predicament is this.
Then what is the
By
grievance
the
that
time-
you can canvass in
By
this
the time,
appeal?
my
then?
lords, the order gets passed. My lords, the entire CRP will come to a close. My competitor, my lords, will
Find
be
no good
entered-
ground in reason to interfere with the improved judgment.
Yes.
The civil appeal is according to.
My lord, they are on medication. My lord, I'll mention. My lord, I'll withdraw it.
This trial and error practice here also is not a healthy practice. Try your luck, then withdraw.
Let's no. I don't want it to be. My lord, here is situation.
Well, you tried your luck, now it's dismissed. So let's
Now
leave
you
it
told
at
me to withdraw it.
that. And then having argued for some time, then counsel for the FNF seeks permission to withdraw the appeal. Permission granted. The civil appeal is according to dismissed as well.
Great.
Item number 35.
35. I'm conscious of the fact.
Same, no interim order. Hearing is on 18th August, so this is by the way 18th August.
Can I?
You asked for a hearing.
Lordship, I filed in 2017. On that day, I was bound to pay 10 rupees.
Challenging provisions of a statute though. Your prayer in that petition.
Consequent resolution passed. But Lord, all that I want, if the Lordship will kindly bear with me.
You don't want that hike in the.
No, not even that.
License
Lordship, next cycle will come on 10/1/26. Before that, the
Now you have a date, Mr. Basu.
Lord,
18th August.
Please see this, my lord. Kindly see this, my lord. Kindly see this.
Now that the date has been given,
See,
you
I
can
will-
ask the High Court. to
I've
take
never been
up on
wanting any date, my lord. Your lordship may kindly look at it. Dates are being given, it's not being taken up.
that. That is hardly a reason for us to interfere with the
No,
denial of interim.
Lord, I'm conscious of the fact that they cannot fix their board. I'm conscious of the fact it's not a subordinate code. But still, my lord, there are certain circumstances. Kindly see that. Kindly see that.
Dates may be given.
No,
You ask
Lordship,
for the matter to be
it
taken.
never reaches. That's why I humbly.
When your IA was heard, a date is given.
No,
You can't say that the matter never reaches.
Your lordship, see, I came here twice with the same request. It is not coming, my lord. I will be happy.
You
to
can
look at
use your persuasive skills before the High Court on 18th.
That's not working. That's the problem, my lord. Your lordship, please,
We cannot have such a confession from you, Mr. Basu,
kindly bear with me.
that your persuasive skills are not working.
No, just 1 minute, lordship. It's not reaching. To have the persuasive skill, it must reach. Your
You
lordship,
can make a mention and ask for it.
it's not being taken up. Will
We
your
find no good ground and reason to interfere with the impugned judgment as the High Court has already fixed 18/8/2025 as the date for the hearing of the main writ petition of the year 2017. The petitioner may
we request the High Court, if your lordship, sir, please.
we request the High Court to take up the writ petition on the date fixed,
And the High Court,
subject to just exceptions.
request to the High Court.
No,
No, your lordship,
we already said request.
17 onwards, you've been waiting. No, your lordship.
We already said request, subject to just exception.
As expeditiously as possible, something that will work. Twice I've come to this court, the third time I'm coming here.
Don't mention the date or prefix, take up the writ petition expeditiously and dispose of this.
Thankful to the court. I know the difficulty in the request, but then something, the client is also in 17 onwards, he's waiting. Christ, he came here. The court directed that it be taken up expeditiously. Now I thought the time limit ought to have been, which I live with. Thank
Item
you.
number 36.
This had two how-
settlement charges are largely confined to section 490. So, Lordship, this is not a dowry related allegation of cruelty or treatment. The case started with a specific instance of.
Very well, we'll issue notice. Anyhow, you've been granted exemption from surrender. Issue notice.
Exemption has already been granted.
498A is not confined to dowry.
Yes, it is not confined to dowry.
Second part is there.
Second part is there, but I have some sufficient on this point. And
Order granting exemption from surrender shall stand extended.
Your Lordship.
Next date.
Your Lordship. Yeah. Lord, the court used.
Anyhow, there's a connected.
Yes, same order, lots 28.
Issue notice.
Is listed.
Tag along with. Tag with.
7245. 7245 of
Repeat criminal number 7245 of 2025.
Lord, can I, in addition, will not take Lord service through standing counsel?
Service shall be effected by all modes including the state. Permission is also granted to serve the learned standing counsel, standing or public nominated counsel for the state of Haryana.
Lord, it's listed on 20th of August.
No, we said tag with. So we can-
Great.
This raises me a very important question. High Court has granted leave. High Court has granted leave. That 134(1)(c). Though it's not binding, but since it is. No, I know. It's, I know this. But then it raises.
This.
There was a stay of trial. From 2014 it is.
9 September. We shall be stay of the trial in.
That is page 229 is the prayer.
220.
229.
229.
229 is not exact to stay further to stay. PDF 253. Stay
What
further.
file am I looking at now? I'm looking at all the wrong files. One moment.
There is some delay maybe, but it's an appeal.
Delay is coming.
Delay 229. Yes. 229. Yeah. The Quit India movement will not be. The thing is continuing that 1930.
Stay further proceedings in CC number 125/PW/2006 on the file of the learned Metropolitan Magistrate Kurla, Mumbai, arising out of FIR number 313 of 2005.
Yeah. That is one. The FIR and charge sheet I saw there are certain mistakes in that.
9381.
And we changed them. Translation there is an error.
Permission is granted to file corrected proceedings
Of the FIR and charge sheet.
in relation to the FIR and the charge sheet.
Yes.
Corrected documents.
Connected to 9381 of 2024, my lords.
Yes.
That's well, the notice will have to be issued and to be tagged along with it, my lords. Well, there is a delay of 97 days.
Yes.
That may
Delay
kindly
control.
continue.
Issue notice returnable on. When is the next date in these matters?
No, that is 9381 of 2024. It's to be tagged along with that, my lord. Now the
But
date
that
is
date
not
seems to have passed. 9381 was supposed to have come up
on
on,
6th of March, my lord. Then
on
thereafter it has
20th
not.
of January 2025. Next
Yes,
date has been given.
No, my lords, it is
When
it is not given.
Say issue notice, returnable law, 23rd September, tag with SL petition for special leave to appeal criminal number 9381 of 2024.
Lordship.
Number 40.
40 is deleted.
40 is deleted.
Some letters there. You're not told about. Reason for adjournment.
6 is deleted.
40 is also deleted. There's a letter. I was told that it's deleted also. There's a letter also for adjournment. 40, anyone is appearing?
My lords, I am an adjournment letter was filed seeking adjournment on personal health grounds, my lords.
Adjourn as per, in the light of the letter dated, there is no date on this. In light of the letter, letter for adjournment has been filed. List on 8 September.
Item number 41.
Because in 41, we had circulated a letter, my lord, for an adjournment.
41, there is no letter. You want an adjournment?
Because my senior is unavailable due to personal reasons.
So
We had asked for a week's
council. At the request of Land Council appearing for the petitioners, not hesitant, list on 16th September.
Obliged.
Item number 42.
May I please?
Yes.
Brother, all witnesses turned hostile. So far as FIR is concerned, it is having brother, only corroborative value, brother. So far as brother, what
recovery? Sickle is recovered at your instance. The murder weapon.
Mere recovery of weapon.
And you were there in the room with her.
Nobody says. Nobody says. Even further, there is no evidence. But there should be something to show that I am occupying a particular place and the occurrence took place at a particular time.
What time was this incident?
Even for that, there is no evidence.
When was the body found then?
The body found on a daytime. On a daytime.
At what time?
But at what time the occurrence took place?
At what time was the body found? As per the FIR. You're not giving us any answers, Mr. Sirajuddin.
Well, the thing is, we have got only these two judgments. Before that, I should say.
No documents are there.
Well, we have through legal advice, we have got only this.
Take time to file all.
Yes.
File the deposit.
We have got some, recently we have got only Hindi versions, but we have sometime already, yes, yes.
Compile and file the relevant documents. List on. How much time will you require?
The vacation we are strict almost 2 months.
List on 16th September.
But.
Number 43.
May it please Your Lordship. Your Lordship, I am here on behalf of the petitioner who is the complainant. His daughter was found dead in
This
2020.
notice is issued though. Notice is issued and the matter is adjourned. We can understand your anguish, but against a notice order, how can we interpret?
Your Lordship, I am here on a very limited bed. The notice was issued 1 year back.
Mm-hmm.
Even if the matter was adjourned, they've not even filed a status report, they've not even filed a reply, nothing has moved, Your Lordship.
In Punjab and Haryana, 6 lakh or more.
I'm not aware, Your Lordship, but the problem is the state hasn't even so much as filed a reply or a.
They only indicate that the matter needs to be taken up expeditiously, but beyond
Your
that.
Lordship will consider issuing notice so that the state at least here is duty bound to file a report.
Probably the last adjournment is 10th of March 25.
Yes, Your Lordship, 5 adjournments, it's the issuance of the notice.
Great, you get that? We will get up on that.
Just allow me to issue notice and allow me to serve the standing counsel. Let
We
them
can't
file a report.
entertain a special petition.
Your Lordship may then at least consider passing an order of limited time hearing, Your Lordship, 6 months disposal at least.
We are not inclined to entertain this petition, sorry, the special petition filed against notice of motion order in notice of motion order. However, keeping in mind the anguish that the petitioner would be facing as the father of the, as a father, we would request the High Court to give priority to the matter and hear the same expeditiously.
Your Lordship may consider giving a time-bound expeditious disposal.
We can't give it time frame for the High Court.
High Court is, we don't have.
Your Lordship has been delaying arrest since 2022.
Expeditiously is as far as we go.
Grateful, Your Lordship.
Yeah, please, Lord. Because after 1 month of the incident of the complaint.
Cross allegations, cross FIRs.
No, Manoj,
You want the FIR
against
against?
cross FIR, Manoj.
Then
Only a 156(3) is filed. That is also.
whatever
an
it is,
afterthought.
they're cross allegations now.
Manoj, that is an afterthought.
So
Because charge sheet is filed in
you
that.
want the FIR against you to be quashed. So your complaint against the others also will quash then.
No, Manoj, I am saying only.
That is the reason why the High Court.
Manoj,
said
charge sheet is
will
filed
look
against
into
you,
it. It's not a
Manoj,
case
that
for
matter,
quashing.
Manoj. Manoj,
Not a case for quashing. Cross allegations are there.
No, Manoj, I'm only saying, Manoj, this is an afterthought. Because once the charge sheet is filed, then he comes up with this kind of allegation saying, oh,
And
that
no
is something.
ground and reason to interfere with the included judgment, especially petitions dismissed.
Grateful.
45.
Where is the evidence of the prosecutor brings?
Not
We have to go to the High Court to get the judgment.
But my lord, I will annex it, my lord. Once
You've
just
got your
one.
father's evidence, but not the prosecutor.
I will annex.
You are raising the issue of the victim, is it?
Please.
She's supposed to have been 12 years old when
Yes.
you took her away.
Almost 11 years old. My lord, one page, page 45, doctor's report.
10 years and 11 months, yes.
Page 45, doctor's report.
11
Just
years.
one page, my lord. But I will annex, my lord. My lord.
I will look at it.
Next, you produce that evidence.
Please, I will.
The deposition of the victim shall be placed on record by the next date of hearing. List one. How much time would you require?
4 weeks. my lord.
18th August. 46. I think this needs to be the same. Notice. Issue notice.
Delay is there.
Delay condone. Issue notice. Returnable on.
Maybe a fixed date.
12th August. Service of note. Service shall be made by all modes, including this.
47. Yes. Because in this case, I have already undergone almost 18 years and a half. So it's a fit case for remission, my lords. On merits, my lord, my name was not there in the FIR. On 161 CR.
Body is recovered at your instance. The child's body, burned body from, where is it recovered from? Some forest.
Open space, my lords. Open
No,
space.
but buried.
Buried, open space, my lords.
Legally, 2013 judgment, Mr. Legally.
Very well.
One or two
Consider,
more.
We'll consider.
issue notice on the delay as well as on the special leave petition. Returnable on 13th August.
Most of it.
Not 13th, 12th August.
Just because the magistrate doesn't have power to review his own judgment, please have 73 onwards.
One of the accused was also arrested.
Please, in 74 minutes,
on 22nd January. He seems to have made a mistake. You may be right in saying that it doesn't squarely fall within 362.
But then signing the orders in a.
But on facts, should we interfere?
No, in facts, it's a purely civil dispute.
There is Justice Sethi's judgment, RP Sethi's judgment.
Please, sir.
362, review may not be there. But if there is some magistrate issued, notice to the summons to President of India. All that can be, he has now actually seen that order at 75. Page 75.
Before
He's
that,
obviously made a mistake.
Before that,
I said that he's accepting
Latch
the,
on to a technical.
73 and 74 also.
on facts. We are not inclined to interfere with the
Allow me a minute. Allow me.
legal proposition. We are with you. This is perhaps stretching 362 beyond.
It's not. It's a purely civil dispute. The land is still with me. In fact, I was
One co-accused is also arrested.
So that will be done.
Not a case.
May I just see 70?
On facts, we are not inclined to interfere with the impugned judgment, especially the petitions accordingly dismissed. We are not on the legal issue.
Wait, please. It's a legal matter, so therefore there's a delay of 210 days.
Delay is not.
Lordship, kindly see page 7.
Your brother gives
the
a
High Court relies on the witnesses who are not supported. My lord,
PW2.
Not supported, my lord. Kindly, may I only show 2 pages? Page 23, my lord, kindly see. Page 23 is PW1.
He's lost one brother, maybe now he doesn't want to lose the other brother.
Page 23, Lordship, kindly see. PW1, the sister-in-law.
Let us see what PW2 is.
Yeah, both, my lord. May I just show PW1 for a minute, my lord? Page 23 first. Para 1, 4th line, my lord. So she came back from school, she said, and out 5th line from the top, it's in the chief examination itself. No one from the house was near the body, but people from neighborhood were present. So therefore, the entire story of prosecution is contradicted here only. Then she goes on to say that there was no one in the house. And she also says that there was no quarrel, etc. Then, my lord, so kindly see the next page 25 is PW2. And
this is PW1 is your own wife, is it?
No, sister-in-law. So PW2's wife, my lord.
Right.
And page 25 is PW2. My lord, so kindly see at page 26 the cross-examination. Para 4, my lord. It is true that when I reached home, I had not spoken to Hari. It is true that I had not met Hari. It is true that I had not filed any report at the police station. The police picked me up from my house and wherever they asked me to sign in the police station, I signed it. But they only rely on PW10, who is the IEO minor, to say that the FIR is true. But there is no recovery.
Cross-examination, what does he say?
Well, that's what page 4. That's from para 4, my lord, page 26 is what I was reading. At page 26, it is true that when I reached home, I had not spoken to Hari. It is true that I had not met Hari. It is true that I had not filed any report at the police station. The police picked me up from my house and wherever they asked me to sign in the police station, I signed because of the fear of the police. It is true that Harilal did not tell anything to anyone in the police station or at home in my presence. We are 5 brothers, 2 of them have died, 3 of us live together, etc. With love and affection without any animosity. Harilal and Rohit live next to me in a separate room. But there is no eyewitness, my lord. The recovery of stone is not proved. The punch witnesses have turned hostile. Not even a single witness has supported the prosecution.
You used to be in the same room with the deceased.
Yes, ma'am. But there is no last scene here, my lord. There is no allegation that I was last seen.
What time is the body?
11 a.m. in the morning, 11:30 a.m. in the morning. And PW1 and 2 is what the court relies on.
Delay condone, issue notice, returnable on 9 September.
I'm grateful.
Service shall be made by all modes, including the.
Item number 50.
Very interesting questions. Law evaluation
on the 19%.
Is that TTCP is now not renewing the license. Is that TTCP is now not renewing the license. And my application, this allow me, sir. So now the plan is approved. There's no dispute. The plan is approved. There's no dispute. The people had come here, even that has been resolved. Now, because of the pendency of this, DTCP is not renewing the license. DTCP, the appellants, Department of Town and Country Planning. So because of that, the matter is not. So because of that, the matter is not able to proceed.
What do they have to renew? Your
the license, and thereafter I have to start allotting the project. About 400 odd buyers are stuck despite a plan being approved because of the pendency of this. And in fact, we have factored a plan being approved because of the pendency of this. And in fact, we have factored in the principal amount of 19 crores, which was not made available by them. And we had filed an RTI, and we got that information. And after
that, you've already factored.
That we have factored.
Beyond that, how much more are there?
Now, they are asking for interest over and above, which they say that should also be considered, which comes over 27 CR. So that is
the interest part of it itself would work out to
27 CR. And they did not file their claim in time. They were barred by this thing. And 14 ceases to exist. 31 has come in. 31 plan has also been approved. And now they are here that they want to reopen that they, because of their default, they want to add on their default, they want to add on to that interest aspect as well.
37. My lords, that is how they look at it. And the position
but you can't keep his application pending.
No, my lords.
He's already paid you
19 odd crores.
19 odd
crores. That's not the issue, which is
We'll say that pendency of this will not preclude that consideration of the.
That's the question. That's the reason why we have approached my lords, and my lords were.
We are considering it. He's already paid you 19 crores to begin with. This SLP, the maintainability is
exactly good. In fact,
yeah, that's correct, my lord. That's correct. The only issue was that when a CIRP starts under IBC, and on the day
your authorities think they are above the law.
No, my lord.
Do not go before the RP and make a claim.
Please understand, my lord. The explanation to section 14, it says that a license can be suspended if during that period the license fee is not paid. That's
why don't you make your claim before the RP? You think you are
that can't be done now because
you are
the amount is huge.
We see that in all these cases, none of the authorities go for the
question of law has to be he can't in the part of CIRP, my lords, he can't get the benefit of not
the request of the learned and request made on behalf of the learned assistant solicitor general. The matter is adjourned. However, we make it clear that pendency of the special leave petition shall not preclude the petitioner from not an appellant, petitioner from considering the application made by the successful resolution applicant on its own merits without reference to the pendency, without reference to the dues alleged dues payable by it.
And more than
So
400 lotteries, they have paid more than 90% of the consideration with that. Because of
You paid
to the I mean,
sorry.
yes.
That's not what.
That's an
Obliged, so deep you.
My lords, but since my lords have already stated in the order that my lords, everything will come in between because he will approach with an application seeking license, and if we have to give license, then it will have a bearing on the SLP which is pending.
Well, if you want the whole project to go down the drain just because you didn't get your money, which you never asked for within time.
It's all about the effective implementation. Of
Everything is beyond time. You don't go to the NCLT, NCLT, nothing is beyond within time.
My lords, the only
And then you want to hold that over their heads and say that unless you pay the amount, I will not give you.
Absolutely not, my lord.
That is exactly what you're doing. You're just blackmailing them.
No, my lord.
Nothing short of it.
Absolutely not.
Nothing short of it.
My lords are getting a date.
Take it up on a Monday at 2 o'clock. It will be taken off.
Obliged, deep you.
Give you a date.
Any day, in second week of July. Any Monday. Subject to my lord's convenience.
August?
That's my lord, because on the second week it will be a reopening.
Or a Friday also is all right.
As my lord.
What is
Friday will be 8th August.
So deep you.
It's on 8th August.
I am seeking a pass over your lordships.
Item?
52, I am seeking a pass over.
52 perhaps requires a hearing.
Yes,
my lords.
We won't take it up.
My lords, I had mentioned it last week.
There's no point in asking for the matter to be taken up on the last.
Very limited prayer. Very limited prayer. I'll demonstrate. Please pass it over. Even I rushed from now.
Very good. Password.
Thank you.
So, with your lordship's permission, in this matter, notices were issued.
This also requires a.
Definitely, your lordship. The only one thing which I want to point out is the petitioner, your lordship. Just one thing. Your lordship had directed the matter to be listed on 6th of May before the Rajasthan Legislative Regulatory Commission. Now, what transpired there requires to be seen, your lordship. I just will pass on the order, which was passed by the Rajasthan Legislative Regulatory Commission in the matter. I mean, just.
What is your copy to the other side?
794.
Yes.
This is the second case.
Yes, sir. This is the big case.
Something about the first case.
Yeah, with regard to the PIL, your lordship, if I may be just be permitted on this. Your lordship's representative appearing for SWML submitted some information during the hearing in the court. As per orders of the Honorable Supreme Court dated 4th April 2025, SWML was supposed to submit the records and data of monthly mining expenses. However, the information is merely a statement showing average monthly mining expenses without supporting documents or records. Now, your lordship, just kindly see what they actually submitted, your lordship, and just the first page of that. If you just one page, I want to show from that. Lordship, it starts with saying, "Dear sir, we refer to the summons dated 24th May 2023. Now, your lordships, when the SLP was taken up, your lordships, the 24th May summons is on page 403, your lordships. That is what my learned senior had shown to you on that day. May you kindly just have a look at page number 403, your lordships.
403 would be the second volume?
Yes, your lordship, second volume. 24th May 2020.
Volume? So many. 403.
Yes, your lordship. Page number 403, and it shall be 14.
And you've got so many volumes here. It's very difficult to know what is what.
Page
separate eye.
Summon to witness.
Yes, your lordship. That's the summon to witness. They themselves are referring to that.
Go ahead.
Your Lordships, this says summons to witness. The first line of the summons says, whereas white letter dated so and so, the commission order dated 21st April 2023. Your Lordships, they themselves are admitting that they are coming in compliance of the summons which were issued on 24th May 2023. Thereafter, they say that the summons clearly specifically mentioned 21st April. Now, Your Lordships, 21st April order is on page 371. Just, Your Lordships may kindly look at page 371 of this, Your Lordship. That is the order.
Yes.
And Your Lordships, the para 6.7 on page 377. Further, Further, in regard to of the details of the month-wise payments made by the petitioner to the MDO, that is SWML, commission-wide data gap dated so and so, asked to furnish the statement of invoices raised by the MDO along with details of the amount entertained or paid for all 5 years, along with the copies of the invoices for the month of March of all 5 years. This information was duly furnished by BLMCL, which is different. Now, para 6.8, Your Honor. The respondent discoms desire SWML to furnish documentary evidence of the monthly expenses incurred by it from the year 2011-12. The said information is not available with the petitioner. The petitioner is a company owned 51% by Government of Rajasthan, has no access or means to access the monthly expenses incurred. Now, Your Lordship, I'll come straight away to the recording of what exactly the tribunal held eventually, Your Lordship.
So where are you heading now for today?
For what? For today?
The reason why I'm showing this is, Your Lordships, they themselves are very well aware that they were supposed to submit not only a chart showing that this is the bill that is the bill.
Not do that. Therefore,
so what they have done is they have not annexed the invoices. They have not annexed the invoices. Now, as a discom, when I have been provided by RERC, first they say that this is confidential. This should not be shared with me at all. Then they file an affidavit which has till date not been served to me. Now, Your Lordships, firstly, these things should be submitted to me because I am the person who's supposed to look into it and see whether there is to submit back to RERC showing that there is a huge gap or whether there is a huge gap or not. And without the annexures, without the invoices, how will I exactly know how much the MDO billed exactly under what heads? Unless I know that, it will be impossible for me to collect the data.
you are now asking for.
Your Lordship, all I'm asking is firstly that this or information, whatever they provide to RERC, a copy has to be supplied to me in advance. One, and secondly, Your Lordship, more importantly, what I want is that
What is the second one?
Second is the only thing, this, Your Lordship, they have to comply in letter and spirit with the 21st April 2023
RERC. Matter is still pending, is it?
Because in fact, the information was submitted. The RERC said, file an affidavit saying that this is true and correct. They have filed that also.
They didn't give me a copy.
Just
because I'm not going to fight on that.
Don't you need an order?
I'm not going to fight on that. We've also filed part of the compliance affidavit before your Lordships. Because it's this same SLP.
Whatever it is you are filing before the RERC, give them.
Surely, nobody can quarrel with that.
Complaint is that you're not sharing it.
If I want to give you a phone call outside the court,
we'll just give you a date.
Yes,
do all that you need to.
The issue is, can you consider?
Yes.
The issue is one serious one of jurisdiction. Can the RERC?
We'll have to hear you. We'll have to hear you, not today. Not today. We'll hear you on a Monday or a Friday.
Your Lordship, I appear on behalf of RERC.
25th July.
Interim order, of course, may have to be extended because the last order said that till next date of hearing,
I've already got it.
No, it's still the next date of hearing.
Yes, the interim order shall stand extended.
Your Lordship, I appear on behalf of RERC, would like to make some submissions.
Not today. Not
So
today.
the order has
Not
been complied with. So Your Lordship may issue direction, they comply with the order. What was asked for a mining
22nd.
expense, they have submitted.
22nd August.
22nd August.
22nd August.
Very great.
We'll hear you on that.
Your Lordship. After that.
Is that group? Individual and group. Yes. Individual group.
Yes, that's the identity, Mother, the issue of the identity. This is a matter, Mother, that your Lordships have to consider because what it does is there's a Section 7 application filed. He knows, Mother, ultimately it's going to lead to a appointment of a resolution, a professional, Mother. So what he does is he floats a company in October. of 2020, floats the company on October. He has 99.7 odd % in that company. And
requires to be heard, Mr.
that's right, that's right.
We'll give you a date.
Your plan is very well.
The plan is fully implemented. The COC is here, the RP is here. I am the successful resolution applicant. It's fully implemented. Lordship may issue notice, but there is no notice.
Notice.
That's right.
Well, that's one more thing.
And for final disposal.
We are asking. We are asking.
Yeah, it was very answered. That's why we heard.
Because may I make just one submission?
Issue notice returnable on September 13th. Reading shall be completed by the set date so that the matter can be taken up for hearing.
Delay be condoned, there's a slide.
Delay condoned.
Details.
55.
Delay within the. Delay is it within the, Mr. Sibal? What is the delay?
Within the period.
Oh, it's refund.
This is how I get instructed.
Only with all due respect, with all due respect,
Plan has been implemented.
Very well.
No, I am only saying that the lordships are deciding an academic issue today because.
Not today.
No, I am saying even when your lordship.
We'll see whether they have a point.
MIB has given approval, my lord, to the transfer of
The
license.
Ministry of Information Broadcasting has approved our license.
That also
The
is flawed.
license is going on.
What's the point of when the order is passed? What's the point of saying all
We'll
that?
ask him if the unsuccessful resolution.
I know that.
And he participated in the proceedings completely. He was satisfied. The COC meeting
We'll
record.
consider on that day, Mr. Ranjit.
No, I'm only saying,
It may not be academic in that sense. If we find a point in what the entire process may have
My
to be
friend has
undone.
pointed out the point which
Not academic.
Look, the definition of group is very clear, my lord.
That is how third council will argue.
No, for the COC.
After the order is passed, this is the new practice we have.
Page 54. Sorry, item 54.
55.
55.
There are two aspects. Number one, they get a conditional stay, 75% deposit, they don't make it. Number two, my lord, from September, they are here. From September 2000.
It's an interim order, Mr.
Lord, they are occupying the commercial property, they have to pay some rent.
Take it up with the High Court. The High Court sees High Court has recorded that he will get instruction.
In January, February, 43 lakhs. 55 lakhs. I'm grateful.
You have other remedies. You have the federal and.
Yes, my lord, but
they've not complied with the
they
order.
not property, my lord, they are occupying.
You must know how to exercise your rights.
Yes,
Have
yes.
you applied for the federal motors?
That's what we have to do that. But we have made an application before the High Court which has been rejected. It was earlier. Out of ₹90,000. St. Mark's Road property, my lord. They are running it as a hotel. 90,000 rupees is what? 99.
No,
Yes. I bow down. I bow down.
Not respondent's remedy in an.
I bow down.
Then,
I bow down. Great.
Great business.
So remand order.
Well, the remand is the reason why we are before a lot. So kindly see paragraph page 6. Well, it's para 17 of the original order has not been complied. That is the reason which I got page into judgment words page 6. Top line. This is the reason to setting aside the order passed by the registrar. Looks like the top starting the line. But without complying the direction in para 17 of the kindly come to para 17 words. That is page 40. Well, this is the person whose case has been rejected by the even the additional district judge in the first round by saying that he is not coming with the truth. Same person, my merit, this is a paragraph 17.
Page 40, is it?
Page 41. So I'm not questioning your lordship. Kindly come to page 41. The registrar should take immediate action in this regard as per the rules and immediately call a meeting and constitute a trust and appoint trustees, make arrangements for trust bank management and conduct a proper investigation regarding the trustee, other persons guilty of illegal misappropriation and irregularities of the trust properties, take action for recovery from the guilty of persons to compensate the loss caused to the trust and take necessary action in relation to the civil and criminal. We are not part of the first part because we are newly introduced. The registrar will be free to consider the names of the 9 proposed persons
keeping in mind trustee's contact and nature being a religious nature and his inclination towards the religion as well as keeping in view of the religious sentiments of the people, keeping in view of the secretary and the safeguarding interest of the trust. Now kindly come to my lords, the order passed by the register now. That my lords, page 50. Starts at 43, lords have come to page 50.
Yes.
My lords, E is the direction, then 5. My lords, I'm not reading. He contacted a meeting, my lords, and considered the names, and verification was sent to the police. Police, they have given a report, my lord, by 50, and it's according to the which no crime has been found registered against the above proposed 9 trustees. Part 2, 3. Then we discuss completely this person's qualification, my lords. Finally, the registrar passed an order as per the
Where is the discussion on the other aspects, religious as what has been mentioned in that paragraph?
That's coming, my lords.
He only gives them a clean sheet with regard to the.
No, not only that, my lord. Antecedents, my lord, that's coming in the earlier paragraph itself, because the earlier paragraphs records, my lords, these people have been selected as per the committee. That is.
There's no discussion on the other aspects which are mentioned in
Page 49. Page 49. Paragraph B. This is what directions given, my lords.
Religious sentiments to see. To see. Where does he see though? He says, I need to see.
Yes, my lord. That's what.
Where does he see after?
My lords, he says, my lords, in the paragraph.
He doesn't see.
Well,
that is the reason why it's remand.
No, it's seen, my lord. That's why.
No, he says, keeping in mind, it is necessary for the registrar to see.
Yes, my lord.
So thereafter, show us where he sees.
Paragraph 6 onwards, my lords. Paragraph 5, I read it, my lords. Police report. Paragraph 6 onwards. Page 53, the Honorable 4th Additional District Director has clarified there was no too many complaints against the Mayank Sam Sundar Das. This is the person against whom it was not considered. That
this is only on the issue of complaints and all that. There's other religious aspects which he's supposed to look into.
Paragraph 7, in the case of the statement of the proposed trustees, applicant side, so and so have been, they will be operated the trust by protecting
the remand order. Go back to the registrar.
Why I'm saying this Suryakant Tiwari, my lords, he is the person. Kindly see the observation against him in the early round of litigation.
This kind of trust, anyhow, these politics are bound to be.
Well, this one person keep on for 15 years agitating the case, not permitting anybody to do
trying to interfere with the order, which is in the nature of a remand order, especially petitions for calling for the
Well, item 58. Item 58 and being. I'm so sorry. Item 58 and being led by Mr. Mukul Rafi. He was in court just 2 minutes ago. I'm praying for a passover. He's on his legs in court level.
Passover, but yeah, he has. Passover.
Well, I should just seek permission for the passport.
59 also. 60 also Passover.
Yes, Your Lordship.
You'll have to wait for one.
Well, the 61 minutes, the entire controversy minutes.
One moment, one. Yes.
The entire controversy herein, my lords, is covered by the judgment of Hitesh Verma, my lords. I will show, my lords. I will show. My lords, my lords may have this particular transcript, my lords. My lords, the complainant himself says that, my lords, the voice was coming from the shaft. Ventilation shaft is always inside the house, my lords. It's coming from the shaft, my lords.
The 2 daughters also.
Yes, my lord. There is nothing against the daughters, my lord. None of the witnesses have said anything against the daughters. They have roped in the daughters or the mother is retired. They are students, my lord. They are suffering for 5 years. Let's stay. in the meeting.
How old are the daughters?
My lords, one is 30 and my lords, one is 24, 25.
Returnable on 7th October.
My lords, stay in the meeting.
Stay off.
Trial court proceedings, my lord.
What is the case number?
My lords, it's SC 36 of 25.
Which page?
Page, my lords, page 29. 29, my lords. Para 829.
Please stay off further proceedings. In SC number 36 of 2020, pending on the file of the learned ASG-2, Additional Sessions Judge -2, Special Judge NDPS, Northwest, Rohini Court, Delhi.
Much
till the next date of hearing.
62.
62.
Yes. May I please, my lords? My lords, this is a case where I am a foreign investor. Two professional directors, my lords, have made a complaint against them because they've done large mismanagement, siphoning of a fund, selling of the company, doing all kinds of illegal activities. I, right or wrong, filed a police complaint. Police, without summoning the main director, who's now, my lords, left India, files a closure report. I go rushing to the High Court. I say, without any investigation, they filed a closure report. High Court, my lords, in all fairness, comes down heavily on the police and says, please conduct further investigation by the special commissioner and relook at this entire matter. My lords, in the relook at the matter, they simply, my lords, adopt the stand in the first report. Just say, this is what is the report says, we agree. This is what we say, we agree. Now, my lords, something has come out very serious. They, in their report, I want to show you just 2 pages.
What is the direction, Mr.
Because direction is go back to the magistrate's court. The problem is that under 178(3), if I go back to the magistrate's court, they can't order re-investigation. That is a constitutional power that can only be exercised by this court as per Vinay Tyagi. Just see 7 minutes. I want to show you 2 things. Then minutes I will answer.
Who are the complainant?
I am the complainant.
There is a closure report. What is your remedy under Bhagwan?
Well, my remedy is that I challenge by way of a protest petition under 17338. But the problem is something else, Milords.
Not 173. Bhagwan Singh gives you a remedy to protest petition.
But Milords,
petition,
which will be
if
treated
you
as
want further
complete
investigation, then you go for 173.
They have Milords just as a post box filed another closure report without even applying their mind.
Now the court merely directs the magistrate to consider all the applications.
Milords, as per Bhagwan Singh,
Where is the cause for grievance now?
That's what I want to answer. Milords, the only way I can get a re-investigation ordered in law is by way of
not re-investigation, further investigation.
Milords, further investigation, the same police station, the same office is doing it and nothing is coming out. Can I just show you one thing and then Milords, I will leave it at that. Just see page 705. My lords will see what they've done. Actually, why is the case for re-investigation? This is last point. Milords, just see 705, something very interesting.
You literally want us to step into the shoes of the magistrate.
No, Milords, I am asking Milords that your lordship could always direct the police to give it to a different department and re-investigate this case.
Thereafter, you have to update. Go through
Milords, that goes into Milords, I'll tell you why. Just let me show page 7. Let me show you one point, then Milords, I'll answer. Please see 705 bottom. Something against me. This is the status report filed after further investigation. During the course of investigation, laptops and hard disks were seized from the office of NextGen Pharma. My entire complaint is this NextGen Pharma is a shadow company. And the same was subjected to analysis by this forensic RFSL. Specifically queried from FSL as to whether this agreement was found to be prepared in any of the laptops seized. However, no such document was found. So, Milords, in their favor against me. Now, please see what they sent to the forensic. One black sealed NK containing ASUS laptop.
All these aspects.
Just see. Now see the FSL.
Be filed.
Milords, just
you already filed an application.
Milords, just
that application.
Milords, I'm sorry. I'm showing you something very interesting. Milords, have seen that it is one laptop.
Not for us to see at this stage.
Milords, something very glaring. You've seen that one laptop that they have sent to FSL, and the FSL says there is no agreement in that laptop. Nothing is found. Now please see 488. They send the laptop without the hard disk.
You're showing something interesting for you for obvious reasons.
Milords, they send the laptop without the hard disk. Without the hard disk. So laptop is gone. Hard disk is never gone for examination. And the police files a separate report again.
Ground and reason to interfere with the impugned judgment, especially if that's according to dismissed.
Oh, bless you.
You have to see what is listed. If an not choose in any event.
My lord, it's seeking a review of a lordship's order.
Maybe when they wanted to go before the same bench.
My lord,
Now it can't go before the same bench.
No, my lord,
So there ends
this
the matter.
prayer was made on 9th, my lord.
So just pass over.
My lord, please see the order.
And I've seen that also. They are now trying to read something into what we might have thought about. Because we never even said anything.
And my lord,
in fact, we came down on you for taking the possession of the property in the manner which
my lord, on 9th of April. 9th of April, your lordship.
And now the order, this application says that we wanted that money to be.
Exactly, my lord. And my lord, 9th April, your lordship is very on the same honorable bench said, let it go to the other bench. Please see your lordship's order at page 13, my lord.
Matter must have come up before.
It came up with your lordship on 13th, my lord.
They said go back to court one.
Yes, but and there they sent it to my lord Justice Pardiwala's court. These people, they go there, file this application and say it has to be listed before the chief's court, Honorable Chief Justice's court. Then it comes back to your lordship's court. When your lordship has already passed at page 13, please see page 13, my lord, of that IA. Your lordship's order. This honorable bench has passed that order. Please see, my lord.
This before.
And then 13.5, they say subject to orders. Yes. Subject to orders of Honorable Chief Justice list before bench presided.
After this,
it goes to the court. It goes to that court. Then they bring it back here. They say that your lordship should hear it.
You can't choose the bench.
Just pass over, sir. So
And even if you have this illusion that I'm going to be sympathetic, I'm not.
pass over, just keep it after lunch if possible.
Very pass over.
Very much, ma'am. Please, oblige.
In item 64, my lord, I have received some documents, my lord, which I want to place before the honorable court, my lord.
You are
Actually, High Court has regarded.
before the High Court. What did you produce?
No,
the High Court says you not to produce the guidelines.
High Court, the guidelines, the High Court has wrongly regarded finding, my lord.
Mr.
Yes, my lord.
What do you say in your writ petition?
My lord, the first,
What is the violation of the guidelines according to your writ petition? Please point out that.
my lord, the High Court first paragraph is incorrect, my lord.
Leave that.
That's why
Your writ petition, let us see what you have raised.
Yes, my lord.
What did you say there? What are the violations according to
Violations are there, my lord.
what violations in your writ petition you point out, please?
Yes, lordship, just my lord. That's why I want to find some documents, my lord.
You are just building up the case as you go along. Before the High Court, you got nothing. So now before I ask you to do something else.
Actually, my lord, some papers, my lord. This is a case of a fraud, I am telling you, my lordship, my lord. Other side has stated the correct facts, my lord. Even the High Court has regarded the incorrect.
You have to at least demonstrate what the violation of the guidelines.
My lord, I will, my lord, lordship, just grant me, my lord, 2 weeks time, my lord.
The request of the land comes.
After vacation, my lord, I will.
Why do you get listed on the last day then?
Matter is adjourned to enable him to.
We received, my lord, since the client has come, my lord, in the morning, we received some papers, my lord, which are very, very relevant, my lord. I do.
We'll continue on.
After vacation, my lord. Any date, my lord.
5th August.
My lords, I am for petition in item 26. My lord, senior appeared, but due to some technical glitch, we could not.
What happened to it now? Matter was adjourned or what happened?
My lords, I was not present at that time. My lords,
Item?
senior appeared.
Item number?
CB Raj.
Item 36.
26. Will you confirm this?
26.
Delay condone dismiss. Matter was heard.
Gururaj appeared. Gururaj was here. She that adverse possession matter.
Please, my lord.
Council appear. What do you want?
Appearance slip.
Oh, appearance.
May I mention item 51?
We are going to come back again.
What is 66?
One of the parties on 66.
Yes.
Yes.
I shouldn't hear it or my brother should hear it.
I have appeared for them. In this matter?
In what they
Those parties are not here. Some other
venture.
Who is the party?
It's India Records.
No, unless I have appeared in this stream of was burdening my brothers, so I said first 6 months.
After that detachment sets in.
Absolutely. Just
2025, passed by this court in civil appeal numbers 4819-4820 of 2025 and connected matters. The miscellaneous applications are accordingly dismissed. Both 58 and 59.
My lords, of course, the SSC then will go by my lord's order.
Not say anything. Let us see how.
But then that's up to the SSC, my lords.
That is all.
Some physical appearance may be allowed to be taken.
Very
Grateful, Your
Master will be direct. Greatly obliged.
Item number 16.
Well,
60.
Look, the High Court in 482 bullets, your lordships have time and again said bullets. The High Court put on the premise that it's a civil dispute.
Notice is issued.
No, but they've
your counterpart asked for time perhaps.
Bullets, they have stayed the proceedings. Your lordships have
can always be unstayed once you make your point before the High Court.
Your lordships have always held bullets and bullets.
Why should we interfere against a notice and stay order?
Look, the stay on the face of it, he says it's a civil dispute.
What is the date of the impute order?
Looks, this is 13th of
November 2024. That's 70 days delay in filing and then
7 months.
we find
70 days.
delay condone. We
The
find
last
good
one.
ground.
Let me permit you to withdraw. I'll approach and seek vacation of the statement.
Don't say that. When counsel for the petitioner, then it's senior counsel appearing for the petitioner, having argued for some time, seeks permission to withdraw the special leave petition. Permission granted the special leave petition is withdrawn, leaving it open to the petitioner to pursue his remedies.
Sorry, I was not aware of that. I was called up. But I did also not want.
In any event, your application as framed is now infructuous because that bench is no longer
No,
there.
but what happens? There is a
Where is
judicial,
that application?
there is an administrative order passed by the order of the Chief Justice, I am told, assigning the matter to this bench.
Exactly.
What I'm told.
Not this bench, the other bench.
No, to this bench.
No.
No, please see, because there is an order on.
I was a party to that order.
I know, Lord, I know.
And we sent it to Justice Pardiwala's bench.
No, but then thereafter, Lord, what happened? Lord, if Lordship could just.
There was no order.
The order passed.
You keep filing application after application.
No, this is the application I filed 13th of May.
How do you do this bench hunting?
No. I'm not, Lord. On the contrary, Lord, this is.
And the statement which you made in this application completely.
Not even a word, Lord, is untrue or incorrect.
This honorable court agreed with the submission made by the counsel of the appellants that upon complying with the order, appellants would be entitled to receive. Did we say this?
No, Lord. Please see what has happened.
How do you read something in our minds?
No. It is not.
On the other hand, I distinctly recall that the Chief Justice was absolutely infuriated with the conduct of the party. How do you take the possession of the premises like this?
Please see.
Immediately give it back. This is what we said.
Yes, Lord. Yes.
Not that we said that you need to be given money for indulging in these kind of actions.
There are 3 times I mentioned to the bench.
Now, enough. We've already passed an order saying that this matter will go back to that bench.
Lord, may I say this?
We have not found any order.
Is hearing the last.
There's no question of the Chief Justice having recalled that order without my knowing about it.
No, we wanted it before to be placed, constituted. When we filed the application.
IA number 98849 of.
Lord, may I say this?
This application is utterly misconceived and is accordingly dismissed.
Lord, may I say this? Lord, 13th of May, there is an order.
Much obliged.
Lord, relegating the matter to court 1.
Note is there on the website.
13th May, there is an order.
13th May order. What
13th May.
That is Justice Pardiwala's order, because you must have said that the application is moved.
Of assigning the matter to courtroom number 1. That is what the order says, Lord.
Courtroom number 1, it will go to the other courtroom number 1.
Justice Gavai's bench, in honor of the Chief Justice. And then, Lord, I'm informed, subject to correction, Lord, that there is an administrative order passed by the honor of the Chief Justice.
No, he only asked for this IA to be listed. And this IA can't go to courtroom number 1 because I was there, not the bench which is now in courtroom number 1.
For the reasons, Lord, I leave it to the court. Lord,
well, you seem to have asked for it.
No, yes,
specifically record.
I have said so because Lord, we wanted this matter to be heard by the
and
bench.
this was on the day that the Chief Justice was retiring.
No, Lord, what happens? Lord,
for what reason did you ask for it to go back to courtroom number 1 then?
We filed, Lord, we informed the bench that this is the prayer. We took out the application prior to them.
Well, the registry also understood it correctly that it need not go to that courtroom number 1, it needs to come to me because I was there in
You
that
have
bench.
absolutely no, as a matter of
This
request
IS
made.
completely misconceived.
No, the request made is
The IS
the lordship of the party.
and is accordingly dismissed. Registry shall list the matter in terms of the earlier order dated
9th April 2025.
4/2025.
Lord, what happens?
Much obliged.
This will be tagged along with Lord another issue which is pending with which I have nothing to do with it. Lordship.
Please.
65.
Lords, the suit was filed, my lords, on the basis that they were in possession of the property. The sale deed of their sale deed is of 2005. I am a bona fide purchaser from 1998 on the property in possession since 1998 till today, my lords. Lords, it was on the
This order which was passed on 31/12/1997 by the collector, by the commissioner, that is retained finality. You never challenged that.
That's in my favor, my lord.
That is not in your favor.
That's in my favor because it releases the land from being a surplus land. I had purchased it in 1998 after that. That's why, my lord, the time when I purchased the land, there was no cloud of doubt over the title, my lord. So without challenging the title, a suit for an injunction is filed, a permanent injunction in which a title has been, as collaterally said, it is deemed to be having title.
Now all 3 courts have held against.
That's why I'm here.
Where is the question?
With great respect, a suit for a prohibitory injunction is filed on the basis, I showed the plaintiff, that they are in possession. The trial court records a finding that the spot inspection which says they have not been in possession. Admittedly, from 1998 on a bona fide purchase, on a title deed, I am in possession of the property since then. The suit was not maintained in the manner in which it's framed, Lord. That's my contention. A second appeal point, Lords, under section 100.
So this is Punjab Haryana.
Punjab Haryana.
Punjab Haryana.
They don't have to
no
frame
substantial.
They don't have to. But your Lordship, there's a judgment which says that even if they don't have to, substantially you'll have to satisfy the test of a section 100 point. Lords, there's a judgment to that. I'll place that. But I'm on the suit. Look at the suit, it is filed. I'm not saying
lost before all the 4 others.
But then the suit was filed as if they're in possession. The finding is against them that they've never been in possession of it. And they could not have been in possession, my lords. The title is of 2000. Sorry, no, great respect. There's an equity point here. It was the retired.
With the improved no. SLP dismissed.
May I place an equity point? That's one equity point.
No, we are not.
From 1998, a retired army.
File an application before the High Court.
Lords,
Not going
then we'll just say we'll withdraw.
No, you don't say anything.
Lords, my title.
File an application there. You don't need our permission to do that.
No, Lords, I'm on a different.
With regard to delivery of possession.
Bear with me for a moment, Lords. Bear with me for a moment. I'm on an equity point, Lords. He was a retired.
We have seen how these equitable orders passed by this court lead to all kinds of abuse and cases, and we need to undertake a fresh exercise all over again.
I'm on a very. I'll place the equity point, Lords. If the Lordship are not satisfied.
With regard to delivery of possession.
No, Lords.
Then what?
In 1998, the land was released, Lords. It was not a surplus land. I purchased the bona fide.
This 78 canals was a surplus.
Was a surplus deed. It was released, my lords. I am a retired army personnel. I went back to my village. My entire savings, my lords, 9 lakhs I have invested in that. It was released from a 426 canals and 78, my lords. From the purchaser of what is defendant number 6. The lordship will issue limited notice to a mediation on this point. Why? Because, my lords,
we are not.
The subsequent allotee is only 28 canals, part of the land, my lords. I have paid 9 lakhs for this and a valid sale deed. So it's a retired army officer, not a solicitor. My lords, will just permit me to withdraw with liberty to appropriate proceeding, not because my title is still valid.
Then comes for the petitioners having argued for some time, seeks permission to withdraw his petition, reserving liberty to the petitioners to invoke such remedies as may be available to them in accordance with law. Permission granted, the special petition is dismissed with the liberty of hospital. We, however, make it clear that we have not made any comment in that regard.
Very great. Very good.
So, Mr. Dr. Muralidhar, now that you mentioned, was this that matter before Surikant which was going on in a connected matter?
Yeah, apparently, well, it's this India record
Film Private Limited, they wanted to complete themselves. That was refused by the High Court against
Same proceeding.
Yes, yes.
No, then
That's why I wouldn't have otherwise.
No, that's why I asked you if it is the same stream.
Yes. Before a bench in which one of us.
That
maybe Vishwanathan,
Punjabi video.
Exactly.
Yes.
Gurbani.
We won't give you a date because you don't know when it will come up.
The matter is coming up on 9th July. So can I request for third week of June?
It's a whole interlocutory orders.
Third week of June.
This matter,
Yes.
this matter stays granted by the division bench on the ground that order 39-2A jurisdiction has been exceeded. Whatever it is you need to say, you will need to go back to the division bench and say it along.
I am only agreeing by the observations made and the entire government given.
We are not hearing it. So
Dr. Bida, I can't.
Like.
My lord, may I just make one request in item 66? I appear for respondent number 3. I have instructions. My physical appearance.
Which item?
66, my lord.
66.
Respondent number 3. I have instructions to appear. My physical appearance.
Date. Some date in July.
We can't give you a date now. Expeditiously, you say. Systematic expeditious. We speak for a bench. 67 will take up after 68. 68.
As a coming up after notice is issued on the consent.
68.
No. But I'm appearing for the respondents. But I may have to file a counter because that's some explaining to do.
No, but you are not even allowing visitation rights. You have taken the children abroad.
That's the next submission.
Not fair to a father.
He says that he's not seen the children since June 24. That's not
fair.
But therefore,
so yesterday they come.
To make one further submission. While
The person who had appeared yesterday, we do not see him here today. He said that one of the children is coming back.
In fact, I was not.
The other child is already over 18.
Yes.
He is not coming.
The daughter is over 18. But the son who's studying in Singapore now, he's traveling to meet the sister, and on his way back, he will be in India. He'll be here in the first week of July. What we would do, my lord, is before we file the counter and the matter comes back.
You take it up, Mr. Rajal. Yes, sure.
Yes. In fact, my lord, even before knowing that they had made that offer yesterday, I had told my lord, my instructing counsel that in July, when the child comes, let us first show our bona fides, let the father have some visitation rights, let the father do it. We'll come back and agree.
No, then permit a video or something.
No, video, my lord, we have been giving him links.
That was what was stated yesterday, that video links are being.
The video links will also continue to be given to him so that he can have that interaction with the child.
You're not able to access the child at least online.
My lords, let me submit. In fact, the government made that there has been a video visitation. Is a totally false government. First of all, my lord, for the last.
Have they been giving you links, video links?
No links.
Not at all.
No
links were given to you.
No links. No, in fact, I want to submit that.
How are they communicated, these video links?
12th July.
How do they communicate them?
Through the council, my lord. Because
Where is Mr. Ashutosh to be? He's on record for you.
Yes, my lord, he has a personal difficulty because of which he is in Calcutta. His father is hospitalized. However, I've spoken to him. No links have been received either by Mr. Dubey or by myself.
But I make it one side.
In fact, my lord,
got my statement. The communication between the parties, my lord, I notice has only been through the council.
Anyway, going forward,
What I will do, my lord, is apart from the child coming in July, in terms of the order, in the interregnum also.
What about the daughter?
Daughter, my lord, also video links. If the daughter is willing to join, my lord, we'll give video links. I'll have to take instructions.
Where is she?
My lord, she is studying in UK because, my lord, she is joined after her 12th exam. She wrote.
And where is the mother?
The mother, my lord, is a resident of Singapore. The child is now studying. The boy is studying in Singapore.
What I intend to submit is that the respondents have chosen to modify an order of this honorable court without any information of myself or.
But your settlement also speaks about depending on the education. Something is stated to that.
December 23, one arrangement.
And then thereafter. Also, that was how it was being done.
Yes.
Mr. Dubey says that he never received them.
No, it happened, my lord, that July 2024, after the children moved, because it's every second Saturday and Sunday, a video link was sent. But I'm told.
That's totally a false affirmation.
I'm basing my instructions. I was told that my list of dates has it and the council will be
If you go into that, you do
council.
No, how was it communicated to Mr. Dubey?
From council to council.
How?
What's
By way of written letter or
WhatsApp message?
WhatsApp message?
WhatsApp messages.
And do you have the right number though?
It is. There's been communications on the same numbers. But what happened, as I realized, is after 12 July, when they did not join the Zoom link, I don't find any communication thereafter every month.
12 July of last year.
Last year, immediately after the children.
June, he did not see the children. After that,
June, the children moved abroad. July, one link was sent on WhatsApp. Father did not join the link. From August, they did not do it.
Bother to send the links also.
No links were not. Therefore, we have to bring back that in the interim and show our bona fides by undergoing visitation rights in July, and the losses could work out any workable arrangement thereafter. Only one fact. The wife is respondent number 1. The in-laws and the sister-in-law are made as respondents 2 to 4. Today, I'm not asking for any relief. I'll come back with an application for deleting those parts.
We have anyway dispensed with the personal. That's in the same order. If you see,
yes,
there are a few submissions. If you allot me permit, I will make. Yes. First of all, the first visitation started from December 2020.
The past you leave it.
No, after
now, we will make some arrangements so that you get to see your son in July, and before that itself, you get to at least see them online, both your son and your daughter.
No, I have a difficulty there. I have filed certain documents earlier also. There were for 2 years, there were virtual visitations which were totally defeated by the respondents. And in fact, the mother was not in India. It was defeated by the sister of the mother who was here in India and the father. Because they were taking care of the children. Children were residing with them. And every Sunday and Saturday, there used to be a virtual visitation. During the virtual visitation, iPad or a book or a gaming console.
You don't live in Delhi?
I live in Delhi.
Why a virtual visitation? They're also here?
That was COVID time, my lords. Thereafter, it was converted to physical visitation. In the physical visitation, my lords, there are observations of the family court as well as the Delhi High Court. If the child has not been brought to the court or the child is being tutored against the father, my lord, child is being tutored against the father. You know, they have not allowed me to present the factual conspectus of the case. In fact, the conduct of the parties that brings out the intention of the parties in preventing me and my son, earlier my daughter, from completely meeting each other. For the last 1 year, it has totally harmed my relationship with my son because I don't know where he is, what he is doing. In fact, my relationship with my son was beginning to get rekindled. And that's when, out of 38 total scheduled visitations, only 5 have been allotted. Physical visitations after this settlement was done. 38 5 out of 3. And thereafter, they've taken the son out of India's jurisdiction.
To each of these contentions, my lord, we have an answer.
No, ultimately, you know who is being psychologically harmed.
Parents don't realize that, but this kind of bickering between them, the impact that it has on the child.
This is
and
not
then this kind of prejudicing one parent, prejudicing the child against the parent.
Identical allegations.
That might in fact turn out to be counterproductive once the child attains the age of maturity.
But all the past allegations,
the child will resent 90%.
But all the past allegations that are now being stated by my friend who's appearing party in person, a contempt case was filed before this Honorable Court. 2nd August 23, this Honorable Court dismissed that contempt case. But today I'm answering.
That was August 23. It is noticed in the order. Well within the December 23 deadline. The difference.
Yes. He, however, undertakes to ensure. We put it on you.
Lordship may say that I've taken instructions and
he however states on instructions that the petitioner would be allowed to have visitation rights insofar as the son is concerned, as he would be returning to India on 1/7/2025. Full stop. He further states that the son would be in India for a period of 1 week and the petitioner would be allowed to exercise his visitation rights from 10 a.m. to 5 p.m. on 3 or 4 days as the child may